few logistical notes before we get started. Each board member is going to have time to make remarks, and then at the end we will take your questions. Today's event is not being live streamed, but it is being recorded, and the recording will be available on our website afterward. Also, although the report is already available on our website, we are printing copies. But unfortunately, as we struggled to complete the report in time for today's release, we were not able to have all the printed copies available for you just yet. Before I speak about the substance of our report, I'd like to start with two key thank yous. First, I want to thank P-Club's dedicated professional staff who worked diligently on the agency's oversight of Section 702 and the creation of this report that we released today. P-Club is headed by a bipartisan board, and each board member is supported by a counselor. The rest of our staff are nonpartisan civil servants. Many of our staff members have worked on this report, including our Section 702 team of attorneys and policy analysts, and an all-hands-on-deck effort, including finalization of this report. Our report is the result of over a year of investigation supported by more than 15 dedicated civil servants as staff members. Many of these staff members have agreed to allow us to name them in the acknowledgements page of our report, and you can see their names there. But I also want to signal out for special thanks Jennifer Hart Fitzpatrick, who served as our 702 team lead for many months during the development of this report, and this summer became our executive director, where she continued our work to ensure completion of this report. Second, I want to thank the many people at the intelligence agencies and Justice Department who worked on the accuracy and classification review of this report. Many details about the Section 702 program's rules and operations are classified, and therefore P-Club's oversight report had to go through the accuracy and classification review process. Although the board is certainly entitled to make our own assessments and value judgments about the value and risks of the program, the accuracy review process ensures that all the facts contained in the extensive factual narrative, as well as the facts that appear throughout the rest of the report, are fully vetted by the intelligence agencies and the Justice Department. All of those facts have been reviewed and verified as accurate by those intelligence agencies and Justice Department. In connection with this accuracy and classification review process, I want to particularly and publicly thank Becky Richards, the Chief of the Civil Liberties, Privacy, and Transparency Office at the Office of Director of National Intelligence. Becky coordinated the accuracy and classification review process and played a critical role in moving this process forward. Without her, I'm not sure that we would have been able to publish our report in time before Section 702 expires at the end of this year. In turning to Section 702, I'd like to start with a very brief background on the 702 program in case we have anyone here in the audience who is not familiar with the program. I'll then speak a bit about our report, including highlighting some key takeaways about the report itself and about the Section 702 program revealed in our report, and a quick outline of the board's recommendations. Section 702 authorizes the government to target non-U.S. persons located outside the United States in order to collect foreign intelligence information, including both the content and metadata of their communications. This program is operated principally by the NSA, but also by the FBI, CIA, and National Counterterrorism Center. Section 702 was last reauthorized in 2018 and is now scheduled to expire at the end of this year unless Congress acts to reauthorize it. Although targets may only be non-Americans located outside the United States, communications of U.S. persons may be collected if they are in communication with a target through what the government calls incidental collection. The statute authorizes the government to make annual certifications to the Foreign Intelligence Surveillance Court, specifying the topics of collection. The FISA court must review and approve these certifications and also approve the targeting procedures, minimization procedures, and querying procedures. The court does not review individual targeting decisions. The querying procedures authorize the government personnel to search through collected Section 702 communications using particular search terms. These terms can include identifiers for specific Americans, and the government refers to such searches as U.S. person queries. The P-Club first reviewed and released a report on Section 702 back in 2014. The report we released today updates, and expands on that 2014 report. This year's report includes a history of the program, an extensive review and explanation of the program's operations and oversight, policy analysis, and 19 recommendations. The PCOB's 2014 report on Section 702 has been the guide for many people in describing the Section 702 program and in setting out the information that is unclassified about the program. Now, 9 years later, we have not only provided a description showing how the program has changed over the past 9 years, but we are also able to provide a much more comprehensive description of the program, including a greater extent of information that has been declassified about Section 702. We made numerous requests for public interest declassification, and a good deal of information has been declassified in response to our requests, although some of that information has already been pushed out by the intelligence agencies prior to today's publication. For example, we had requested a decertification of the number and topics of the certifications, and earlier this year, the IC released that there are three such certifications: foreign governments and related entities, counterterrorism, and countering proliferation. Our report that we have finalized also includes a classified annex providing further details about the program's operation, and we have shared that with cleared staff for the congressional committees that have jurisdiction over PCLOB in these matters. In addition, I wrote a separate statement, and board members Beth Williams and Rich DeZino also wrote a separate statement. While we worked with the intelligence community to declassify as much information as possible, in the classified annex, we have further discussion of some matters that could not be declassified, and there are notations in the report indicating where such discussion continues in the classified annex. After our lengthy review, the board concluded that Section 702 is highly valuable to national security and that it poses serious privacy and civil liberties risks to both U.S. persons and non-U.S. persons. Excuse me. I want to highlight, excuse me. I want to highlight three key takeaways about the report itself before I turn to the details about Section 702. First, PCLOB's report should provide a new, comprehensive, and authoritative source for information about the Section 702 program, including serving as an authoritative source for the scope of information that has been declassified about the program. Second, the report shows that all 5 board members agree that the program is valuable to protect national security and that significant reforms are needed. No board member has called for the program to lapse, and also no board member has called for a clean reauthorization of the program. Third, the report shows that all 5 board members agree that the FBI needs to do more to ensure that safeguards for privacy and civil liberties are sufficient. The FBI has taken some recent steps to increase safeguards for privacy and civil liberties and to improve compliance with the rules, and these steps are welcome. But all board members agree that the FBI must do more. I also want to highlight a few takeaways about the Section 702 program that are described in the report. First, the Section 702 program has been growing over the years. From 2013 to 2022, the number of targets increased by 276%. And in the past 5 years, it has nearly doubled in the number of targets. Also, although we don't have metrics for the total collection of communications under Section 702, we know that with regard to upstream collection, which is consistently represented a very small portion of the program, in 2011, the number of internet transactions that were collected was approximately 26.5 million, and that number has increased to, in 2021, being approximately 85.3 million internet transactions, so over a 3-fold increase. Also, the ways in which intelligence agencies have relied on Section 702 has expanded. For example, the reduced U.S. military footprint in numerous regions of the world has increased the need to find new means of gathering information. Second takeaway I want to flag about Section 702 from our report is that the program has been valuable in protecting the United States from a wide range of foreign threats, including terrorist attacks in the United States and abroad, cyber attacks on U.S. critical infrastructure, and both conventional and cyber threats posed by China, Russia, Iran, and North Korea. To demonstrate the program's value, our report includes selected declassified examples, some related to counterterrorism, strategic competition with major powers, defending against cyber attacks, and slowing proliferation of weapons and theft of advanced technologies. Additionally, the report includes some statistics that demonstrate the value of the program. For example, in 2022, almost 22% of NSA's reporting on terrorism was sourced in whole or in part to Section 702. Third, the board finds that Section 702 poses significant privacy and civil liberties risks, most notably from U.S. person queries and batch queries. Significant privacy and civil liberties risks also include the scope of permissible targeting, NSA's new approach to upstream collection, a new sensitive collection technique, how data is initially ingested into government repositories, as well as incidental collection and inadvertent collection. Fourth, the new information contained in PCLOB's report includes new details to shed more light on the extent to which the government has relied upon Section 702 in criminal investigations and prosecutions. The board's 2014 report had already clarified that the FBI routinely uses U.S. person queries of 702 data at preliminary stages of its investigations. Our updated report explains how the government has only used information obtained from Section 702 in 9 criminal prosecutions. It also describes how outside of the category of victim or defensive queries, FBI has been unable to identify any cases in which a Section 702 U.S. person query provided unique value in advancing a criminal investigation, and the government cannot identify any criminal prosecution in which it has relied on evidence returned by a U.S. person query. With the intelligence community's apparent increased reliance upon Section 702, it is becoming more important than ever that policymakers work to address growing privacy concerns. We argue that these threats can be reduced while preserving the program's value in protecting America's national security. To that end, we make 19 recommendations for policy changes to the program, which we believe would strengthen privacy and civil liberties protections and thereby improve the program. I won't go through all 19 right now, but I do want to briefly mention the 7 of those recommendations that are recommendations for action by Congress, since we are approaching the sunset of that program. The remaining 12 recommendations pertain to steps that the intelligence agencies can take on their own. Our first recommendation for Congress is that they should codify the 12 legitimate objectives for signals intelligence under Executive Order 14086. These provide important privacy and civil liberties protections for signals intelligence collection, including the Section 702 program, and intentionally narrow the grounds upon which the government can otherwise collect under Section 702. Such codification would provide the necessary clarity in conferring explicit jurisdiction to the FISA court to ensure that this executive order is properly enforced across the judicial branch. Our recommendation, too, urges that Congress should codify the prohibition against abouts collection by removing NSA's ability to restart it without congressional approval other than in certain exigent circumstances, and that is outlined further in the recommendation. Our third recommendation is the one that is already drawing the most attention, of course. That is our recommendation that Congress should require FISA court authorization of U.S. person query terms. The board believes that the most critical safeguard for Americans' privacy rights is to require individualized and particularized judicial review for all U.S. person query terms. Specifically, the board recommends that Congress require FISA court review and approval under the current standards of reasonably likely to retrieve evidence of a crime in order for the government to access the results of reasonably likely to retrieve foreign intelligence information or evidence of a crime in order for the government to access the results of any query using U.S. person query terms. The board also recommends that Congress include 2 specific exemptions, one for exigent circumstances and the other for where the government has obtained explicit consent. Recommendation 4 urges that Congress should codify any exemptions or exceptions to the Section 702 querying procedures in order for such exemptions and exceptions to be implemented. Our 5th recommendation urges that Congress should require that NSA perform and publish an assessment of the feasibility and value of proposed methodologies for estimating the scope of incidental collection of U.S. person information, including the use of statistical and cryptographic techniques. One fact about incidental collection, which I failed to mention, I know my colleague Ed Felton is going to talk a little bit more about here today, is that we don't currently have any such estimates for the scope of collection of the information about Americans. Recommendation 6 urges that Congress should codify a requirement that the government submit to the FISA court a random sample of the targeting decisions and supporting written justifications from NSA, FBI, and CIA for after-the-fact judicial review as part of the annual Section 702 recertification process. And our 7th recommendation to Congress is that Congress should strengthen the role of the FISA court amicus and improve transparency for FISA court opinions. This includes specifically specifying that the cases in which amici for the FISA court shall be appointed include the annual Section 702 certifications, and that the Congress specify that amici be granted access to information in connection with matters in which they are appointed to the same extent as the government, and that Congress should authorize the amici to petition for appeal of decisions. And with regard to declassification of FISA court decisions, the board recommends that Congress set a time limit for such reviews so that the declassification review and public release of each such decision, order, or opinion must be completed no later than 180 days after the date on which that decision, order, or opinion was issued. Finally, I want to speak very briefly about my own separate statement that I mentioned before. I wrote a separate statement pertaining to our recommendation 3 regarding FISA court authorization for U.S. person queries. I have joined in this recommendation, but in my view, it should be further strengthened. Congress should require that before FBI may access the results of a U.S. person query conducted at least in part to seek evidence of a crime, the government must obtain approval by the FISA court under a probable cause standard. This would ensure that such queries fully comply with the Fourth Amendment and would be consistent with criminal law in other contexts. A search through Section 702 communications data seeking information about a particular American constitutes a search under the Fourth Amendment, and current query standards are insufficient to meet constitutional requirements. This reform is critically important to ensure that the querying aspect of the Section 702 program is on a sound constitutional footing and protects Americans' right to privacy in their communications. I urge Congress to make this reform an essential component of a reauthorization package. So again, thank you for joining us today, and I'll now turn it over to my colleague, Board Member Ed Felton.
Good afternoon. Thank you, everyone, for your time today. First, I'd like to join my colleagues in thanking our professional, nonpartisan PCLOB staff who work with agencies to ensure the factual accuracy of the report. It is the team's and their dedication and long hours devoted to this project over the last 13 months and to the mission of PCLOB that are at the heart of everything we do as an agency. We thank you. My bipartisan board colleagues and I don't agree on everything, but I believe we do agree on many important things. We agree that the 702 program is valuable in protecting Americans, and accordingly that Congress should renew Section 702 with some important reforms. Although we disagree on the details of the reforms, I think we do agree that significant reforms are needed. Today, I'd like to give my own perspective briefly on 3 areas relating to intelligence collection: upstream collection, abouts collection, and incidental collection of U.S. person information. First, upstream. Upstream refers to collection that occurs inside the United States on the telecommunications backbone with the compelled assistance of U.S. providers. Upstream can be a challenging area to discuss. It's highly technical, and many of the details are classified, and for good reason. These factors can leave a space in the public discourse, and people may be tempted to fill that space by imagining the worst. The board and our staff have been able to probe the details of upstream, including the deep technical details, and although there are limits on what I can disclose in a public forum, I can reassure everyone that we have examined upstream in detail, we've asked the hard technical questions, and we've engaged with the intelligence community regarding public interest declassification relating to upstream, with the results as reflected in the report. An important question about upstream is the precision of the technical mechanisms for collecting communications in upstream. In other words, how precise are the technical mechanisms in place to ensure that upstream collects only communications that are to or from a properly targeted selector? In recent years, NSA has improved the technical precision of upstream collection, adopting a technical architecture that is well designed to limit collection to only the tos and froms of tasked selectors, and NSA should be commended for these improvements. The board recommended that NSA periodically evaluate these collection mechanisms to maintain their precision as the technology evolves. Second, abouts collection. Abouts collection includes collecting communications in which the tasked selector is neither the sender nor recipient of the communication, but rather the selector was contained in the body of the communication. NSA ended abouts collection about 5 years ago, a decision that I believe was justified by the relatively limited value of abouts compared to the privacy and civil liberties implications of the practice. In the intervening years, NSA has not resumed abouts collection, and the government has not argued that the resumption of abouts is needed at present. In light of all of these factors, the board has recommended that Congress codify the end of abouts collection with a carefully crafted exigent circumstances exception as described in the report, which is designed to meet any need that might arise to resume abouts due to changes in circumstances. The third main area I'd like to cover is incidental collection of U.S. person information. This occurs when communications are collected from a properly tasked selector, but those communications involve a U.S. person. For example, if a properly targeted selector is at one end of a communication and a U.S. person is at the other end. Some non-zero amount of incidental collection is inevitable, but it would be very helpful for Congress and the public to know how much incidental collection of U.S. person information is actually occurring under Section 702 authority. The short answer is that we don't know, and no one knows. PCLOB has recommended in the past, and members of Congress have asked, that NSA should create an estimate of the extent of incidental collection of U.S. person information under Section 702 authority. But the agency has declined to provide an estimate, arguing that it's not feasible. The intelligence community says that it's not technically feasible to get a precise estimate at reasonable cost. But after technical discussion of this issue with intelligence community experts and based on my technical expertise, I remain convinced that it is possible for NSA to provide an estimate with stated margins of error of what fraction of the items collected under Section 702 falls into each of three categories. First, communications involving a U.S. person. Second, communications not involving a U.S. person. And third, communications whose U.S. person status cannot be determined with reasonable effort. This estimate can be done by various methods, such as statistical sampling, at a reasonable cost. It may turn out that many or even most of the communications fall into that third don't know category. Even if this is the case, this knowledge would be useful to Congress and the public in understanding and weighing the benefits and risks of Section 702 collection. To its credit, NSA has consulted with technical experts outside the agency on methodologies for estimating this incidental collection, and I urge the NSA to continue these collaborations. The board in the report recommends that Congress require NSA to formalize this process. In closing, I want to thank the agencies across the intelligence community for their cooperation, for the information they provided, and for their willingness to answer questions and follow up with information. Their effort to provide information and fact-checking for this report, and their good faith work to enable PCLOB to carry out our oversight role more broadly speaks well of their commitment to privacy and civil liberties. I'll pass on to my colleague, Travis LeBlanc.
Good afternoon. My name is Travis LeBlanc, and I am one of 5 members of the Bipartisan Privacy and Civil Liberties Oversight Board, which I have served on since 2019. Today's release of the Privacy and Civil Liberty Oversight Board's 2023 Section 702 report marks an important moment in the consideration of whether to reauthorize the expiring surveillance law. This is the second report that our board has issued examining the surveillance activities authorized by Section 702 of the Foreign Intelligence Surveillance Act. Our 2023 report considers the significant statutory and process reforms that have been made to the program in the last 9 years. Indeed, during the course of our investigation, the executive branch has continued to make reforms to its practices, particularly this year as Section 702 approaches reauthorization. Many of these reforms have resulted in improved protections for U.S. and non-U.S. persons, better training for intelligence community personnel, more internal agency oversight, more judicial oversight, and fewer compliance errors. Generally speaking, these reforms are welcome, and the intelligence community should be commended for their continuing efforts to improve compliance, oversight, and privacy and civil liberties protections in connection with Section 702 activities. Despite these reforms, however, there remain very significant privacy and civil liberties concerns with the program's operation, and those concerns are shared unanimously across the board. Accordingly, the board's 2023 report offers 19 recommendations to improve the program, including 7 legislative recommendations for Congress that Sharon spoke about just a few moments ago, including a recommendation that Congress require judicial approval for the FBI and other intelligence agencies to query Section 702 collections for the communications of U.S. persons. As our full board unanimously agrees, Section 702 is a highly valuable foreign intelligence program insofar as it is targeted towards foreign individuals who are reasonably located abroad. On the other hand, Section 702's necessity and value decreases substantially when used to incidentally collect Americans' electronic communications and then search those communications to investigate Americans' domestic activities, oftentimes for matters that are completely unrelated to the foreign intelligence purpose for which they were collected. In my view, the querying of U.S. persons by the intelligence community needs more oversight and could be further aligned with foundational democratic principles that promote transparency, accountability, independent oversight, and reform, even in a highly classified national security program. We know that Americans' communications are incidentally collected under Section 702 surveillance. While we don't know how many U.S. persons have had their communications incidentally collected under 702, we do know that there have been a massive number of queries with American identifiers in recent years. Just the FBI alone, in 2020, there were 1.3 million queries, 3.4 million in 2021, and approximately 204,000 in 2022. Although the number of U.S. person queries by the FBI dropped dramatically in 2022 due to a series of reforms that had taken place in the last year, that's more than 550 U.S. person queries every day, and in fact is many orders of magnitude larger than the number of U.S. person queries performed by the rest of the intelligence community combined. When you add all of the U.S. person queries in the last few years, they amount to approximately 5 million such searches by the FBI and thousands of searches by NCTC, CIA, and NSA, all seeking to obtain Americans' private information, and all done without the individualized and particular approval of a court. Although Section 702 is touted as a foreign intelligence tool, it is apparent that a key feature is domestic intelligence and criminal law enforcement. While it may be efficient to search Section 702 collections for U.S. identifiers 5 million times, we must also look at the efficacy or value of those queries. During the course of the last 2 years, we have had many classified briefings on the value of the Section 702 program, including briefings specifically on the potential value of U.S. person queries to the program. Thus far, however, I have seen minimal to negligible examples of unique value of querying U.S. persons though so many times under the program. So I ask, what do we have to show for approximately 5 million queries? Where are the criminal prosecutions associated with 5 million queries? Where are the Section 702 F2 orders requiring the FBI to get a warrant and a predicated criminal investigation? In 2018, the number of F2 orders obtained was 0. In 2019, the number was 0. In 2020, the number was 0. In 2021, the number was 0. And at the same time, we know that there have been compliance infractions where the government failed to obtain an F2 court order when it was supposed to do so. In short, the current court order requirement in Section 702 is too limited and has failed to offer any meaningful protection for privacy and civil liberties. But beyond the massive querying of Section 702 collections for U.S. persons, the lack of examples where such queries could not have been pursued with consent or were not exigent, the board's report also finds that compliance incidents are also rampant at FBI in particular. This includes the improper searching of political leaders, such as members of Congress, social advocates, religious community leaders, and even individuals who provide tips or who are victims of crimes. In particular, we now know that the FBI conducted hundreds of searches of social advocates associated with the individuals arrested by law enforcement during the George Floyd protests. In one period alone, non-compliant queries related to civil unrest numbered in the thousands. Thousands of U.S. persons exercising their First Amendment rights on domestic issues. To be clear, at the time of the queries, FBI personnel had no information connecting the individuals or the conduct to information that would be contained in FBI's Section 702 acquired information. The government has also reported a number of queries concerning individuals involved in domestic drug and gang investigations, human trafficking investigations, and others, absent sufficient cause to believe the query terms would be in Section 702 acquired information. For all these reasons, I wholeheartedly support the board's recommendation that the government obtain a court order before reviewing the contents of U.S. person communications in Section 702 databases. Such a program warrants court approval of individual U.S. person queries, which would reduce compliance errors, promote accountability, and build public trust in a surveillance program long beleaguered by a wide range of privacy and civil liberties threats. 5 million searches by the FBI of Americans' information is 5 million too many. While Section 702 is vital to our national security, its value wanes as it focuses on domestic activities. Today's report sends a clear recommendation to Congress. The government should be required to obtain a court order before viewing Americans' private communications. As I mentioned earlier, we do not currently know the number of U.S. persons whose communications are collected as part of Section 702. Since 2014, the board has recommended NSA calculate and publish several metrics designed to provide insight into the extent of incidental collection. And since that time, members of the House Judiciary Committee have also urged the intelligence agencies to provide an estimate of the scope of incidental collection. The privacy and civil liberties harms created by incidental collection have only increased since 2014. The intelligence agencies have consistently declined to develop a methodology for counting or estimating U.S. person communications, primarily on the basis that doing so would be infeasible or would be more privacy invasive. Our report concurs fully with the 2014 report on this issue in its recommendation that the intelligence agencies count or estimate the number of U.S. person communications collected as part of Section 702. We would like to see the intelligence agencies fulfill this recommendation, as doing so will provide much-needed transparency to the program. Indeed, recently a research group at Princeton University proposed a novel approach to estimating incidental collection that may lay a path forward for the intelligence community to finally fulfill the board's 2014 recommendation. Although we do not yet have a count on the number of U.S. persons whose communications are collected, we do know that in calendar year 2022, more than 246,000 non-U.S. persons were targeted under Section 702. For the entire time I have been a member of the board, I've advocated for the intelligence community to develop a database tag so that whenever an analyst comes across the communications that they reasonably believe involve a U.S. person, they tag those conversations or communications accordingly. This is an important step to ensuring data fidelity and obtaining basic facts needed to evaluate the privacy and civil liberties aspects of Section 702. The board's report makes many other recommendations that I also support, but as you all know, it's a very long report, 300 pages, and we'll be here all day if I walk through them all. Before concluding, however, I would like to express my profound gratitude to the PCLOB staff who tirelessly worked for 2 years so that the board's report could be published today. I would also like to thank the hardworking employees across the entire intelligence community who professionally supported our work during this investigation. I'm also very confident that we would not have completed our report without the support of the administration at its highest levels, including the President, Vice President, Director of National Intelligence, Attorney General, the FBI Director, CIA Director, NSA Director, National Security Council, and many others. Each have been involved in assisting the board in its review. We had the opportunity to spend hours with many of them as we worked on the report, and their time, effort, and engagement on the issue was critical to the board's oversight. All of these stakeholders took our oversight review seriously, and while they may or may not agree with all of our recommendations, I am very confident that they all remain committed to and are steadfastly working every day to improve privacy and civil liberties protections across the intelligence community. Lastly, I would also like to thank my fellow board members. Ours is a small agency. The board conducted much of the investigation under COVID-19 pandemic protocols over 2 years and confronted a number of obstacles, including strict timelines and onboarding 3 new board members, including one who arrived only in the fall of 2022. The bipartisanship all board members exhibited throughout the investigation was critical to executing our 2023 Section 702 report. The engaged discussion, earnest debate, and insightful analysis between all board members facilitated a report that will be an important contribution to the potential reauthorization of Section 702 by publishing key facts, critical analysis, and impactful recommendations. As you all know, we're a bipartisan board. In my view, we are at our best when the diverse views of all members are presented in our reports so that Congress, the executive branch, and the public are able to consider varying approaches on how best to balance national security activities with privacy and civil liberties. Having now spent hundreds of hours in meetings with and reviewing the views of my fellow board members, I know we all share a commitment to the mission of the board and that our general views on the Section 702 program are much closer together than they are apart. I look forward to continuing to work with all our board members to best assist Congress, the intelligence community, and the public with the consideration and adoption of the recommendations in the board's report.
Thanks, guys. So I think the board is ready to take some policy questions. If anybody has them, I would just ask that you give us your name and tell us where you're from.
Thank you for your question. I think all of us up here today have tried to outline for all of you how, despite some of those comments, there actually is much area of common ground, and I hope that readers of the report will recognize that. We obviously do have some key distinctions in our views, most notably over FISA court approval of U.S. person query terms. That is a very clear difference of views that Congress has already been thinking about and will be evaluating, of course.
Stuart Baker. I apologize. I started with the dissent because I always read social opinions the same way. They said, and I think I heard you confirm, that your recommendation isn't just limited to FBI searches, 3 or 4% of the data, of the 702 data that they have access to, but to all intelligence agency searches, of all of the 100%
I'll go first, others may, oh, you want to go first? Go ahead. So you're correct. Recommendation 3 covers all the intelligence agencies. It does have several points of accommodation to some of the concerns that you raised. First is that the recommendation is Congress should require FISA court approval before they access the results of a query. We have been advised how so many queries do not have hits, and so it would not come into play there. We also have recommended that Congress include exceptions for exigent circumstances and for situations where there's the actual consent of the query subject to use their selectors, so it would go there. As far as the 12333, the board has looked at 12333. This report is focused on 702. The board is likely, since, as you well know, so much of what the intelligence agency do is under the authority of 12333. We are likely at future junctures to examine other activities conducted under the authority of 12333, and that will be the time to make any recommendations with regard to that authority, in my view.
I will just add that, as Sharon shared, this report is limited to Section 702. I actually wish that we could provide the data on the number of queries and the number of hits on those queries. I think that would be useful information to the public if you were able to see that. In my view, I think that the challenge that we fundamentally face is that this is that queries are done for both foreign intelligence and law enforcement purposes. And it's not always clear at the time that the query is being performed whether it's done for foreign intelligence or for law enforcement. And that challenge means that if you limit it only to one agency, an agency that has a foreign intelligence and a law enforcement mission, it becomes very difficult to ensure that the foreign intelligence access does not end up outnumbering or essentially creating a large, massive workaround to any limitations on the law enforcement use. Also, from a U.S. person perspective, I'm not sure that the potential harm or intrusion is actually all that different in the intelligence context than it is in the law enforcement context. Here we were trying to balance a number of factors, including recognizing the current standard that the intelligence community works with, and using that. And there has been a large desire, at least I've heard it and seen it, and you probably all have seen it as well, to have Congress codify current practices. This is, by the administration, this is fairly consistent with that, while recognizing that, look, if one doesn't know while recognizing that the agencies can still run a search, and they only have to deal with going to the court if they want to look at the content of anything. And that again, another compromise that was being made to account for potentially the fact that 5 million queries could could ultimately end up burdening the court system quite a bit. And so this is an accommodation to allow at least the intelligence community to be able to to gain whatever information it gets from no results, which we're told has some value to the intelligence community, while not having the court involved on every single one of these if it's actually if the court is going to ultimately issue an opinion where they're going to then learn that there was nothing in the database anyways. So trying to balance the judicial resources as well.
Anyone else?
Hi, Tanya Riley with CyberScoop. Can you talk a little bit about why probable cause did not make it into the recommendations?
I'm just going to say it's in my separate statement. It's very much in my separate statement. If you want to read that, I don't know if the other board members want to opine.
Yeah, I'll say that. First of all, I don't think any of us would object to a probable cause standard, just to be clear. None of us would object to it up here. Probable cause is a term that makes sense in the criminal law context. In the foreign intelligence context, it gets much harder to ultimately determine what is probable cause, especially when, in many instances, the foreign intelligence search would not be about a bad actor, maybe just someone related to a bad actor, or you know, someone who just might have information that is relevant. We were also concerned about having different standards for different agencies. You heard me mention the issue with FBI and sort of having a law enforcement mission and a foreign intelligence mission. One standard was one uniform standard is easier to apply, and it's the same standard that is currently done by the intelligence community, which of course means that at least from the day-to-day standpoint for an intelligence analyst, it's the same legal standard they should be meeting, but there is a neutral judge that is now placed in it. And lastly, I think we have to recognize that the relative value of these, at least in my view, is of U.S. person queries in circumstances where the unique relative value in circumstances where they could not obtain consent or where there weren't exigent circumstances is quite minimal there.
So just to add one thing to what Travis said, Travis talked about the difficulties with having different standards for different agencies. I think there would be similar difficulties with having different standards for foreign intelligence purposes versus for law enforcement purposes. And and in many of the practical cases, either those purposes overlap or it's not clear when a search is done whether it's more likely to result in foreign intelligence or law enforcement related results. And so having different standards for different types of, for those two different purposes would be difficult. And given that in the foreign intelligence setting, a reasonably likely standard, at least for me, was seemed better targeted. It would follow that having the same standard on the criminal side as well would make sense.
If I could just jump in one more time, I want to emphasize something that Travis did note, which is explicit in the recommendation, which is that everyone is fully comfortable if Congress should choose a probable cause standard. And I think what you're hearing is some pragmatic concerns that led to the recommendation itself being crafted the way it was.
Madeline Hughes with MLEX. And the first recommendation that you guys made was to codify the executive order. And you mentioned how that goes with the European Union data privacy framework. How does that framework and other potential privacy agreements, international ones, help you guys inform what you're recommending in this report?
All right, I'm going to jump in first again. So one thing I want to make clear, which I don't think I had a chance to say at the top, is we explicitly note in this report that not only do those 12 purposes apply to all signals intelligence, including Section 702, but the board agrees that the current certifications, the current purposes that Section 702 is authorized fit, that the intelligence agencies are currently in full compliance with those 12 purposes. This is toward the longevity of implementation of that executive order and those commitments. And also, it's a way, as we look at potential risks down the road for overbroad targeting and some concerns that the FISA definition of foreign intelligence is very broad. I hope our report gives comfort that the intelligence agencies aren't pushing those boundaries with 702 right now, and that recommendation will help to ensure that that continues to be the case going forward.
John Sacklariadis from Politico. A lot of folks who I've talked to in the national security camp or within the administration have expressed criticism of the fact that you guys, as an executive branch agency, took a different line than the president in particular by recommendation. You're an executive agency. You're also an independent executive agency. So I sort of know where this is going, but I want to give you a chance to
Exactly. We are independent. We are an independent oversight body. We are within the executive branch, but we're independent.
Anyone else? No? All right. Thank you very much, guys. Appreciate it.